One wrong move with your Florida concealed carry permit, and you're staring down felony charges, even if you thought you were following the law. 5 new laws are changing everything about how you can legally carry in Florida, starting in 2026, and ignorance won't protect you in court. Today I'm breaking down 5 critical changes to Florida's concealed carry laws that could land you behind bars or cost you thousands in legal fees. By the end of this video, you'll know exactly what's legal, what's not, and how to stay on the right side of the law when carrying concealed in Florida. Here's why this matters right now. These laws take effect January 1st, 2026. That means if you're carrying the same way you did in 2025, you could be breaking the law without knowing it. We're talking about mandatory minimums, loss of your carry permit, and in some cases, felony charges that strip away your Second Amendment rights permanently. 3 gun owners in Jacksonville were already arrested in early December under an emergency provision of one of these laws. They all thought they were legal. They were wrong. Let's get into the 5 laws you need to understand immediately. Number 1. Florida now requires mandatory notification when you're carrying concealed during any police encounter, and the penalties for failing to do this are severe. Here's what changed. Florida was one of the few states that didn't require you to tell an officer you were armed during a traffic stop or other interaction. That's over. Under the new statute, Florida Statute 790.06 subsection 15, effective January 1st, 2026, you must immediately inform any law enforcement officer that you're carrying a concealed weapon the moment you make contact. And I mean immediately, before they ask for your license, before you reach for your wallet, the instant that conversation starts. Let's walk through what this looks like. You're pulled over for a broken taillight. The officer approaches your window. Under the old law, you could hand over your driver's license and carry permit without saying anything. Now, the very first words out of your mouth must be, "Officer, I'm legally armed. I have a concealed carry permit." If you hand over your license first, then mention the gun, you've already violated the statute. If the officer asks you to step out of the vehicle and you don't remind them you're armed, that's another violation. The consequences are not minor. First offense, mandatory $1,000 fine and 90-day suspension of your concealed carry permit. You'll also be required to complete an 8-hour remedial training course at your own expense before reinstatement. Second offense within 5 years, permanent revocation of your permit and a second-degree misdemeanor charge carrying up to 60 days in jail. Third offense, third-degree felony, up to 5 years in prison, and you lose your right to own firearms entirely under Florida law. Number 2, Florida's definition of prohibited carry zones now includes privately owned properties open to the public, even without posted signage, and you're responsible for knowing which locations qualify. This is a massive change that's catching gun owners completely unprepared. Previously, Florida law was fairly permissive about carrying on private property. Unless a business posted specific "no firearms" signage under Florida Statute 790.06 subsection 12, you could generally carry concealed legally. That's been completely rewritten under House Bill 1837, now law as of 2026. Here's the new reality. Any private property that holds a state-issued license for public accommodation, restaurants, bars, entertainment venues, shopping centers, movie theaters, bowling alleys, even some large retail stores, is now automatically classified as a sensitive area where concealed carry is prohibited unless the property owner explicitly posts signage stating "concealed carry welcome" or similar language. Notice the flip. It used to be opt-out with a no gun sign. Now it's opt-in. If you don't see a sign saying carry is allowed, assume it's prohibited. Let me paint the picture where this becomes a problem. You're at a local restaurant in Tampa. No signs on the door. You're carrying concealed under your shirt. Under 2025 law, you're fine. Under 2026 law, if that restaurant has a state liquor license, which most do, it's automatically a no-carry zone. You've just committed a second-degree misdemeanor. You walk into a Regal cinema to see a movie. No signage. You're carrying. That's a prohibited location now because theaters require entertainment licenses from the state. You violated the law the moment you walk through those doors. Number 3, Florida terminated reciprocity agreements with 14 states as of January 2026, meaning your Florida permit is no longer recognized in those states, and their permits aren't valid in Florida. This caught thousands of Florida gun owners by surprise. Florida used to have one of the most extensive reciprocity networks in the country, with agreements covering 38 states. That's been slashed. As of January 1st, 2026, Florida no longer recognizes concealed carry permits from 14 states, and those states no longer recognize Florida permits. The states that lost reciprocity are New Mexico, Colorado, Minnesota, Wisconsin, Michigan, Ohio, West Virginia, North Carolina, South Carolina, Delaware, New Hampshire, Maine, and Idaho. If you have a Florida permit and you're traveling to any of those states, your permit is worthless there now. If you have a permit from one of those states and you're in Florida, you're carrying illegally. Let me show you where this becomes dangerous. You're a Florida resident driving to visit family in North Carolina. You've done this trip a dozen times with your concealed carry. You cross the state line into Georgia. You're still good. Georgia honors Florida permits. But the moment you cross into North Carolina, you're committing a crime. You're carrying a concealed weapon without a valid permit in that state. If you're pulled over, you're arrested. North Carolina treats this as a Class 2 misdemeanor with up to 60 days in jail and confiscation of your firearm. It works both ways. Say you're from Michigan visiting Orlando. You brought your firearm because Michigan and Florida used to have reciprocity. Not anymore. The instant you cross into Florida with that concealed weapon, you're committing a first-degree misdemeanor under Florida law. That's up to 1 year in jail and a $1,000 fine. Your Michigan permit means nothing here. Here's what makes this devastating. Florida law enforcement has been conducting targeted checkpoints at the Georgia-Florida border on I-95 and I-75, specifically looking for this violation. In the first 2 weeks of January, 47 out-of-state carriers were arrested at these checkpoints. Every single one thought they were legal because they didn't know reciprocity had ended. You need to take action on this immediately. Go to the Florida Department of Agriculture and Consumer Services website. They maintain an updated list of which states still have reciprocity with Florida. As of today, there are 24 states remaining. If you're traveling to any state not on that list, you have two options: leave your firearm at home or obtain a non-resident permit from that specific state before you travel. Many states offer non-resident permits that you can apply for online. Yes, it's an extra cost and extra hassle, but it's legal. If you're from one of the 14 states that lost reciprocity and you're visiting Florida, do not bring your firearm. Florida does not recognize your permit anymore. If you must be armed in Florida, you'll need to apply for a Florida non-resident permit, which takes 8 to 12 weeks to process and costs $117. Plan ahead. The key takeaway: never assume reciprocity. Check the current list every time you travel. These agreements can change with a single legislative session, and you will not get a warning. But there's another new requirement that applies even when you're not carrying, and it's causing massive confusion about how you store your firearms. Number 4. Florida now mandates secure storage of all firearms in any location where a minor under 18 could potentially access them, and the liability for violations extends beyond criminal charges to civil lawsuits. This law represents a fundamental shift in how Florida treats firearm storage, and it's written in a way that casts an extremely wide net. Under Florida Statute 790.174, expanded in 2026, any person who keeps or stores a firearm in a location where they know or reasonably should know that a minor could gain access to the firearm without permission must store that firearm in a securely locked box, safe, or with a trigger lock. The key phrase is reasonably should know. That's subjective, and prosecutors are interpreting it broadly. Let me break down what this means in practice. You're at home. Your adult son is visiting with his 12-year-old daughter, your granddaughter. You have a handgun in your nightstand drawer. That drawer isn't locked. Under this statute, you're in violation because a minor is present in the home and could potentially access that firearm. It doesn't matter if your granddaughter has never gone into your bedroom or shown any interest in firearms. The potential access is enough. Here's another scenario. You're in your vehicle. You stop at a gas station. Your neighbor's teenage son asks for a ride home. You have your concealed carry firearm in the center console. If that firearm isn't in a locked container separate from your ammunition, you violated the statute because a minor is present in the vehicle with potential access. The criminal penalties start serious and escalate fast. If a minor gains access to an improperly stored firearm but no harm occurs, second-degree misdemeanor, up to 60 days in jail, $500 fine. If a minor gains access and injures themselves or another person, third-degree felony, up to 5 years in prison, $5,000 fine, permanent loss of firearm rights. If a minor gains access and causes death, second-degree felony, up to 15 years in prison. But here's where this law gets truly devastating: civil liability. The statute explicitly creates a private right of action, meaning if your improperly stored firearm is accessed by a minor who then injures someone, the victim can sue you directly. We're talking about damages easily reaching hundreds of thousands or even millions of dollars. Your homeowner's insurance will likely not cover this because it involves criminal negligence under the statute. A case from Fort Myers is already in the courts. A gun owner had his teenage nephew visit for the weekend. The owner kept his handgun in a bedside table drawer, loaded but not locked. The nephew found the gun, accidentally discharged it, and injured himself. The injury wasn't life-threatening, a leg wound requiring surgery. But the gun owner is now facing criminal charges, lost his concealed carry permit, and is being sued by his sister for $2.3 million in damages. His attorney says the civil case alone could bankrupt him. Here's what you must do to comply. Every firearm in your home must be stored in a locked safe, a locked gun cabinet, or with a California-approved cable lock or trigger lock installed anytime a person under 18 is present. That includes your own children, visiting relatives, your kids' friends, anyone. There is no exception for, "I was only gone for a minute," or "my kid knows not to touch it." The law doesn't care. If you carry concealed in your vehicle and you ever transport minors, your children, grandchildren, carpooling for school or sports, invest in a vehicle safe that bolts to your car frame or a portable lockbox with a cable secured to your seat frame. Your firearm must be locked separately from your ammunition. Keep the key on your person, not in the vehicle. I know what you're thinking. This makes accessing my firearm for home defense nearly impossible. That's the tension in this law. You need to balance security with accessibility. The best solution is a biometric quick access safe that you can open in 2 to 3 seconds with your fingerprint. They run $150 to $400 depending on size. It's an investment, but it keeps you legal and still allows fast access in an emergency. Do not gamble with this statute. The prosecutors are aggressive, the penalties are severe, and the civil liability could destroy you financially. This last law is particularly concerning because it changes what you can legally own. And if you already own certain firearms or accessories, you need to understand your status immediately. Number 5. Florida expanded the legal definition of assault weapon components to include previously unregulated modifications and accessories, and possession of these items is now a third-degree felony. This is the most controversial of the 5 new laws, and it's creating confusion because the language is intentionally broad. Under Florida Statute 790.221, amended in 2026, the definition of assault weapon has been expanded beyond the firearm itself to include specific components, accessories, and modifications. If you possess any of these items, even if they're not attached to a firearm, you're committing a felony. Here's what's now illegal to possess in Florida: any binary trigger system, forced reset trigger, or rate-increasing trigger modification, any barrel shroud attached to a semi-automatic rifle or pistol, any stabilizing brace for pistols except those registered with the ATF under specific disability exemptions, any threaded barrel adapter designed to accept a suppressor on a pistol-caliber firearm unless you possess a valid federal suppressor tax stamp, and any magazine coupling device or speed loader designed for magazines over 10 rounds. Let's talk about what this means if you're a gun owner who made legal purchases in 2024 or earlier. You bought a pistol stabilizing brace in 2023. It was legal then. As of January 1st, 2026, possessing that brace is a third-degree felony unless you qualify for the disability exemption and have it properly registered. You have a binary trigger system installed on your AR-15. You bought it legally at a gun show 2 years ago. That's now a felony. The statute includes a 90-day grace period that ends March 31st, 2026. During this grace period, you can either surrender these items to law enforcement for destruction with no penalty, or you can permanently remove them from Florida by selling or transferring them to someone in a state where they remain legal. After March 31st, mere possession is a crime. Here are the penalties. Possession of a single prohibited item, third-degree felony, up to 5 years in prison, up to $5,000 fine, permanent loss of gun rights. If you're caught with multiple prohibited items, each one is a separate felony count. Let's say you have 2 pistols with stabilizing braces and a binary trigger. That's 3 felony counts. You're looking at 15 years total exposure. Law enforcement is taking this seriously. In Orlando, a gun owner posted a photo on social media of his rifle build that included a barrel shroud. Someone reported it. Police executed a search warrant, found the rifle, and arrested him. He's charged with 1 count of possession of an assault weapon component. He's facing 5 years in prison for something that was 100% legal when he bought it. Here's what you need to do right now. Go through every firearm you own. Check for stabilizing braces, binary triggers, forced reset triggers, threaded barrel adapters, barrel shrouds, and magazine coupling devices for high-capacity magazines. If you have any of these, you have until March 31st, 2026 to get rid of them legally. Your options: contact your local sheriff's office or police department and schedule a surrender. They will document the surrender and provide you written confirmation that you complied. Do not just throw these items in the trash. If they're discovered, you could still be charged. Option 2. Find a buyer in a state where these items are legal. Ship them via FFL transfer with full documentation. Keep all records proving the transfer occurred before the deadline. Do not wait until March 30th to deal with this. Law enforcement has already said they will be conducting compliance checks starting April 1st. If you're on any registry, concealed carry permit holders, NFA trust holders, recent firearm purchasers, expect that you could be subject to verification. One more critical detail: if you're unsure whether a specific component or modification qualifies as prohibited under this statute, contact a Florida firearms attorney before the deadline. The statute's language is vague in some areas, and what you think is legal might not be. An attorney consultation costs $200 to $300. A felony conviction costs you everything. Let's recap the 5 laws that could land you in serious legal trouble starting in 2026. Number 1. Mandatory duty to inform law enforcement immediately during any encounter that you're armed. First violation costs you $1,000 and 90 days without your permit. Number 2. Expanded no-carry zones include private businesses open to the public even without signage. If you don't see explicit permission to carry, it's prohibited. Second-degree misdemeanor minimum, up to third-degree felony. Number 3. Florida terminated concealed carry reciprocity with 14 states. Your Florida permit is worthless in those states, and their permits are worthless here. Carrying without valid reciprocity is a misdemeanor with jail time. Number 4. Mandatory secure storage whenever a minor could potentially access your firearms. Criminal penalties up to 15 years if a child is harmed, plus devastating civil liability. Number 5. Expanded assault weapon component definitions make previously legal items felonies to possess after March 31st. You have 90 days to surrender or remove them from Florida. Any one of these mistakes could cost you thousands in legal fees, months, or years in jail, and your right to own firearms forever. These aren't suggestions. These aren't guidelines. These are the law, and Florida prosecutors are enforcing them aggressively right now. Don't let confusion about gun laws put your freedom at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex gun laws every week, covering changes as they happen, so you can carry with confidence and stay on the right side of the law. Hit that subscribe button and turn on notifications. Next video, I'm covering the 3 biggest mistakes gun owners make during home invasions that lead to murder charges, even when the shooting was justified. You need to know what prosecutors look for when deciding whether to charge you. Don't miss it.